Welcome, Willie.
Thank you.
I'm very excited to have you here because we had a conversation when you came and presented to our company about sectional titles and gave us some insights that after more than 20 years in business, I didn't know. So I thought we need to share some of those insights with the general public out there because sectional title is a major part of property in South Africa. And I believe owners, buyers, sellers, as well as people who want to go into real estate, whether it's managing agents or selling agents such as ourselves, will absolutely benefit to know more about it. But first of all, tell us who you are and why do you think you can talk to me about sectional title?
So my name is Willie Roos. I'm an attorney and conveyancer. I'm also the CEO of a company called Stratfin. Stratfin is a financial services provider in the sectional title industry. I also head up a company called Conveyancer Administrative Solutions, which is an administration business that manages schemes but under court order. So it's not appointed by the owners, but appointed by the court to sort out the problems where scheme has become dysfunctional. I've practiced for over 25, 30 years and been in the industry from 2008 in the sectional titles industry and started Stratfin in 2014. So been a long time in the property industry and practice as a property attorney and property expert. So I know a little bit. I'm not saying I know everything. I mean, we all learn every day, but at least there is a couple of things that I do know.
No, I think, I think you know a tremendous lot. And after all these years, are you still happy you made that choice to transition?
Absolutely. I always joke and I say to the attorney friends that they're still practicing and I got it right. So I don't have to practice anymore. I am still involved with DTB Attorneys, who are our largest collections attorneys firm, so are still involved with that. But I do not practice on a daily basis myself, don't draft the summonses and applications and so forth, but are still involved on a daily basis with that, but not doing it myself.
Okay. So just for people out there, we often get asked the question, what am I buying when I buy sectional title? And I often think, every country is different. And we also have a lot of people from overseas. So just for context, I learned recently that in New York, if you buy space, you don't buy the air above the space and you need certain permissions and all that. What do you buy in South Africa when you buy sectional title?
So in sectional title, you're buying from the middle of the brick walls to the inside. That is your section. So that is the main living area. And then you also become an owner of the common property. So that's the outer portion of the brick, so halfway and out, and then all the land and the stairs and all the amenities and so forth, the swimming pools and so forth. And you are a joint owner in respect of that, and you share in that in accordance with your participation quota. So your percentage of your size of your units as a percentage of the whole of the scheme. So you have your property rights in respect of the inside, then basically of your unit, plus then you own together with all the other owners the outside and all the other spaces in the scheme.
So with the benefit of that ownership of the common spaces, can I assume some responsibilities?
Absolutely. The Sectional Title Schemes Management Act places a responsibility on owners to contribute for the maintenance and upkeep of that. We do see that people don't necessarily know and understand that. I've done lots of training sessions at new schemes and so forth, where owners are saying, but I am paying my bond, what is this levy? And then we have to explain to them, but you have to maintain the outside of the buildings and maintain the roads and the security and the common property electricity, common property water usage and so forth. So all of those things is a shared expense, and that must be paid by the owners then in accordance with their participation quota.
And it does get a little bit even more complicated when you are in a sectional title within a larger estate, and we have quite a few of those in Gauteng, where you would, I mean, for instance, at Steyn City, you'll pay a levy for being in the estate, and then you pay a levy for the actual sectional title complex where you own an apartment. So how does that work in general?
So the sectional title scheme would generally be built on an earth within the homeowners association, and as such the sectional title scheme is then a member of the homeowners association, and that scheme have a obligation then to pay levies to the homeowners association, but the owners in the sectional title scheme have an obligation to pay in respect of the sectional title scheme for the maintenance and upkeep of that. So in general, what you would have is then a levy for the sectional title scheme, but that levy would include a levy to the homeowners association that then is paid for the upkeep and the maintenance of the homeowners association. But there are very involved ways of setting these things up. And you mentioned Steyn City. Steyn City, as I understand, is a HOA without members even. So the directors makes the decisions, and it's not the owners. So the memorandum of incorporation actually give the full power to make decisions on behalf of the homeowners association to the directors, and the owners that living there have very little say. They must just comply and pay the levies for the maintenance and upkeep. So very difficult and intricate ways of setting up these different schemes.
Yeah, and I think maybe at this point we can just outline what people can look out for when they're purchasing, and what is the difference actually between an HOA and body corporate, because you hear that terminology, and then when you say levy for the HOA, then levy for the body corporate, then we hear special levy, then when you get a levy statement from an owner, you see all sorts of other little abbreviations, so people get quite overwhelmed because over and above that, there's rates and taxes. So if we can just break it down for the general public out there, when we are setting off to buy our first property, more or less what should we be looking out for?
Okay, so let me start with the homeowners association. So in a homeowners association, you have separate urban. So every stand is separate, and you become the owner of that. And then whatever is built on that forms part of that stand, and you are the owner of that. The roads, clubhouse, entrance, wall surrounding, and so forth, all of those things would then be the common property, and you would then help maintaining that in accordance with the rules or the memorandum of incorporation of that homeowners association. A homeowners association is generally a company, so it's set up as a company not for gain, and then it will maintain and it will have the obligation in terms of the MOI to maintain all that common property, but you as the owner will be responsible for your own earth and your own house and so forth. So this is your own property within a bigger scheme that have some communal areas that is maintained by the HOA. With a sectional title, you actually are buying the inside of your unit, like I said, from the brick inwards, halfway from the brick inwards. That is what you own, and then the outside is also maintained by the owners as part of the common property in accordance with their levies that they pay, and you pay in accordance with your participation quota, which is the size of your unit as part of the whole of all units. So that's basically the difference between the two. The one is a legal entity under the Companies Act. In general, there are common law homeowners associations and so forth as well, but in general now homeowners associations are formed under the Companies Act, and sectional title is formed under the Sectional Titles Act and the Sectional Title Schemes Management Act. So different legislation applicable to the two different types of entities. And then, as you said, you can also get a sectional title within a homeowners association as well, that is a member of the homeowners association. So levies is determined in general by looking at what the expenses of the homeowners association or the sectional title scheme is, and then it is divided in accordance with, in the sectional title schemes, divided in accordance with your participation quota, and then in a HOA in accordance with the memorandum of incorporation, and in general there's a levy per stand that is being charged. All the different little amounts that you also can get onto your account can relate, for example, to common property water usage, common property electricity, and so forth. So those things can then be divided. In sectional title, all these expenses should be divided in accordance with your participation quota. So your percentage that you would pay in accordance with the whole of the expense. Special levies. A special levy is a levy that is raised, and let me deal with sectional title first. In terms of the sectional title rules, it is raised where it was an unbudgeted item that cannot wait until the next financial year. And then trustees are entitled to raise that as a special levy because it's urgent and it has to be done immediately. A water tank burst on the roof, so nobody's got water, it was not maintained, and there is no money in the budget to pay for that. They need to get water, so a new tank has to be installed. It's going to cost 20,000 Rand, and that is then divided between the 100 owners in accordance with their participation quota and then recovered from them. And the water tank is then installed. In HOAs, their memorandum of incorporation can also make provision for special levies. Also, normally expenses that were not planned for, and that becomes urgently necessary to be done. And then they can then determine that, and that is then divided by the owners. If there's 100 units in the scheme, then divided by 100, and everybody pays for that. So that's in general how the levies work. And then since 2008, all owners in sectional title schemes are liable for their own rates and taxes. So prior to 2008, the scheme paid the rates and taxes to the council, but in 2008 the law changed and every owner became liable for his own rates and taxes. So when purchasing a property, you must make sure that your details are listed with the council so that you get your rates and taxes account and pay that. Otherwise, they might at some stage come and execute and sell your property because you've never paid rates and taxes. And then you say, well, I wasn't aware that I must pay it. But yeah, be aware that there is an obligation to pay rates and taxes.
And all of these amounts are usually paid monthly, am I right?
Correct.
Because overseas, often you find properties, property taxes and related amounts are payable annually. And often you find, I would say in Europe, the majority of times, your apartment blocks, every owner decides for themselves what they want to do. So there's no maintenance, no joint responsibility unless all the owners voted to give each other that joint responsibility. So it's an interesting difference because it will lead me to the question that we often see when we start selling properties is unpaid levy. And we've seen cases where for 5-6 years an owner hasn't paid their levy. So what happens, and I guess you can also tell us more now about what your company actually does, but what happens when you have a block of 100 apartments, and how many can we expect not to be paying their levy, and what happens next?
Yes, so all owners are obligated to pay levies, and as you said, it's generally paid monthly, but that is in accordance with the decision of the trustees. So the trustees actually have the authority to determine how that levy is payable. So once the budget has been accepted by the owners and the trustees then adopted that in accordance with a resolution, they can then determine how it's paid. And in general, in South Africa, we say it's paid monthly, but they can also say it's paid yearly. So that is
Okay.
possible. So it can be said to be paid yearly. Um, I think on the Stratfin website, we actually have a resolution where we say it's paid yearly, because that makes your collections also easier, because if somebody doesn't pay immediately, then you can immediately start with the legal action to recover the whole year's outstanding levies.
But
So,
that's because it's in advance, not in arrears.
well, it's then determined for the year, so it's in
Okay.
advance, correct. So then you would then recover that because it's then payable on passing of that resolution. So it is possible to also charge, as you say, in Europe, but in general, the going way, or the way that it is done in South Africa, is it's payable monthly. When we started Stratfin, we were seeing about 5% non-payment of levies in schemes. We currently, when we're assessing schemes, are seeing 25 to 30% non-payment of levies. So over the last 10 years, it has risen dramatically, the non-payment of levies. So it has become a problem in South Africa, for whatever the reason might be. Maybe there are more people involved or purchasing in sectional title schemes that were never in property, so they don't understand the obligations. Or maybe it's just the economic climate in South Africa that is actually pushing people to make that payment as a last payment, as a grudge payment. So don't
Yes.
want to pay that, and it's a last payment that they will pay.
Is there also maybe a factor where the general cost of living is so high that the levies become quite high in relation to the property? Because we often see sectional title units where you've got levies of 2.5, 3,000 rand, but it's a one bedroom, small two-bedroom apartment maybe. So that adds to the cost of owning that property quite tremendously.
Absolutely. So in general, what one will see is the lesser amount of units there are in the scheme, the higher the levies will be,
Yeah.
because the same amount of expenses in respect of that scheme has to be divided in accordance with the participation quota, and there are fewer payers. So there are fewer people that are actually contributing to that 100% that needs to be paid. So if you have a scheme of 20 units, and they've got a night and a day guard security, it's exactly the same for a night and a day guard with a scheme with 200 units. So therefore, the smaller the scheme, the more the levy will probably be in respect of that scheme. And then there are also some requirements in terms of the Sectional Title Schemes Management Act that are pushing up expenditure, but which is actually to the benefit of owners. For example, the 10-year maintenance plan. So all schemes need to have a 10-year maintenance plan in place, and they need to have a budget for that, and they need to save for that so that they can maintain the scheme over a 10-year period. So if you're going to paint in year 6 or 7, then the first 6, 7 years, you have to then get that money in so that you don't have to raise a special levy in year 7 and make people pay it immediately, all of that, and you've actually collected that over a longer period of time, and then you pay for the maintenance in that regard. So because that is a legal obligation, schemes must have that. It also gives effect that the levies are higher than what it was previously, where schemes didn't budget for those types of things.
Who makes sure that 10-year maintenance plan is in place?
So the trustees have a fiduciary duty to act in the best interest of the scheme, and they should implement a 10-year maintenance plan as the managers of the scheme. So they're in charge. They're like the directors of a company, and they are in charge, and they should make sure that a proper plan is drawn up and is funded, and the levies are collected from the owners.
Okay. So then you've seen now a rise of 30% of non-payment. So that's basically means that 2 out of 3 homeowners, sectional scheme owners, pay for the other 1%. So every third of your neighbors is not paying levy. So how do you
Absolutely.
get involved?
Absolutely. So Stratfin assists schemes that have financial problems, and we do that. We've got a very unique model where we actually give the scheme funding, which is not need to be repaid. And we then proceed to collect the outstanding levy from the owner, but on the basis then that interest is charged on that levy, and the interest is then paid over the collection period in respect of that. And we also pay for the legal fees to recover that as well, but on the basis that the fees are the recoverable fees in terms of the rules of the scheme. And in general, it is prescribed management rule 25 that deals with that, and it should be a taxed fee. So it's the fee that the court determines, which is the reasonable collection fee. So that goes in front of a court official that then looks at that fee and say, yes, it was a reasonable fee in accordance with a tariff that forms part of the Magistrates Court Act and the High Court Act, and you then charge in accordance with that fee. So we charge that, and that is also then recovered from the debtor. If the debtor does not make an arrangement and doesn't pay, the process goes right through from issuing of summons up to sale and execution of the property, and the property is eventually sold by the sheriff in execution. And then when the property is transferred, the new purchaser, in terms of that agreement with the sheriff, when they purchase the property through the sheriff's auction, is then liable to pay the levies to the body corporate to enable the transfer to take place from the sheriff then to the new purchaser. So the body corporate at that stage then gets paid.
Right. So this is actually a very important point you make here, because often we see auctions around us, and people say, "Oh, I bought this property for whatever low amount," but the purchaser has to pay the levy, then not the seller.
Correct. So the purchase price is not only the purchase price that is paid to the sheriff, and there is that misconception, they bought the property for 10,000 Rand or 5,000 Rand or sometimes 1,000 Rand. But if the levies are to the value of the property, then obviously that new purchaser is now paying a price that is to the value of the property, because he must pay those outstanding levies. The purchaser is also liable to pay, in terms of Section 118 of the Municipal Systems Act, also liable to pay the municipal bill for a period of 2 years prior to transfer. So he's also liable to pay that. So it is not only you look at the purchase price paid at the auction to the sheriff, but you also have to take into consideration the other expenditure that is payable in respect of the acquiring of that property, which includes the levies and the rates and taxes, and other amounts due and owing to the council. The courts look at it in that manner. It's called the Opperman principle, when they actually take all of that into account to determine if that price was a reasonable purchase price or not.
Right. So if a person owns a sectional title property and they're battling with the rates and the levy amounts, and they just don't pay it for years to come, would you say, because what I'm hearing is the purchaser has to pay all that, but usually the selling price is next to nothing. So that seller is actually better off either coming up with the payments and then selling on the normal market, open market, to get an actual market related value for their property, or maybe they just not stop paying their levy altogether, in the beginning. Where I guess what I'm trying to say is, often you find people maybe wait for too long, and then it becomes such a losing project that they lose the property, but they also end up with absolutely nothing when it's sold on auction.
Absolutely correct. And remember that when that property is sold in execution, whatever is paid for to the sheriff as the purchase price, so let's say that 10,000 Rand that we were discussing, if that is the purchase price and your outstanding bond is 600,000 Rand, then you still owe the bank the 590,000 Rand, and the bank can still come after you, and that judgment debt that the bank has against you stands for 30 years. So they can execute on that judgment debt for the next 30 years. So whatever property you purchase after that, they movable and immovable property, they can come and attach and sell that for the next 30 years. So it's a very dangerous game to play, to think that you're not going to pay your levies and you're going to wait it out, because you still remain liable for the bond, and you actually lose all your equity, that you could have built up in that property. So a far better approach is, when you are realizing that the expenses are now too much for you to carry, then to get an estate agent involved like you guys, and then try and sell that property and at least recover that equity, because now the property might be worth 700,000, you owe the bank 600, your levies are outstanding 10, you walk away at least with 90,000 rand in your pocket, that you can start out something afresh, maybe a bigger scheme where the levies are less, maybe a smaller little unit, whatever the situation might be. So always better to sell yourself rather than let it go through the court process, because in that court process you will lose everything. The equity, you will lose everything. You're not going to walk out of there the winner in respect of that. So at Stratfin, we do have a help you sell program. So where we have
Oh, that was
acquired,
going to be my question. Yeah.
so where we acquired the rights in respect of those levies, in respect of the money that was advanced to the scheme, we actually do, on each and every step of the legal process, we follow up with the debtors, and we would say, we've issued a summons against you. Don't you think it's better that we sell your property? Can we not get estate agents in the area involved to try and help you to sell that? You're going to lose your equity, your bond, and your levies does not exceed value as yet. There is equity for you in there. Rather take your equity and move on. And we try and do that, but unfortunately, people, when they owe a lot of money, they get to the point where they act like ostriches, stick their heads in the sand, and don't want to do anything. And then the day or the week before sale and execution, then they phone, can we do something? Can we now sell? And then you've gone through the whole legal process, and to stop at that stage does not make financial sense for the body corporate, for a business like Stratfin, and we wouldn't stop at that stage. We will then go ahead and rather sell and recover the money at that stage. So better do it as quick as possible when you realize that there is a problem. Rather get an estate agent involved, rather get your property on the market, and sell and get something out of that.
And at that point, let's say the seller has realized that they should rather act sooner rather than later. At that point, would you also assist them in negotiating with the bank? Because let's say they owe more to the bank, or as almost as much as what the market value would be, and then there's still the levy debt and all that. So would you help them negotiate with the bank?
Absolutely, we did one yesterday. So yeah, we definitely do. We actually also go to the banks and we show them what is outstanding to the body corporate, what is outstanding to them, what the estate agent's commission is, what's owing to the council, and we try and get to an agreement where all the parties are giving up something to make sure that the deal works, so that the person can walk away at least without debt. So we try and do that as much as possible, yes.
Okay. And you do hear, because I mean, obviously I've come across such sellers, and you often hear, no, but no one ever told me that I owe this kind of money, or no one, I never heard that it's already in the courts and that there's a judgment against me and that there's an auction booked and all that. Is it possible for an owner not to know? So how long does it take for this entire process, and would they have received notifications along the way?
So it is possible, theoretically, that an owner wouldn't know that legal action was taken, but there's so many ifs and buts, that it's unlikely, but it is probably possible. So firstly, in terms of the Sectional Title Schemes Management Act, your unit is chosen as your domicilium citandi et executandi. That is the place of service of legal process. So if you rent the property out and you're sitting in the UK and you're not paying levies, and the summons is served at the unit on the door, and your tenant don't contact you and say, listen, there's a summons that has been delivered, then you won't know. and one goes through the legal process, and eventually there is an attachment of the immovable property. Again, at that stage, there is service required. So again, at that stage, the owner must be notified that there's now going to be an attachment of the immovable property. The courts are getting very strict in that regard, and in most instances, they require personal service. Not all instances, but if it's a primary residence, for example, then there needs to be personal service on the owner. So wherever they are, they need to be found. And if you can't find them, then you have to bring an application for substituted service. So you will then publish it in a newspaper. And so I'm saying theoretically it is possible that they won't know, but in general, owners know. They know, and they also know that they've got an obligation to pay levies, or one hopes that they know
Yes.
that they have an obligation to pay levies, and they just refuse to pay, or they just ignore it, or whatever the situation might be. Also, something of importance to note is that if you're not happy with the services of your managing agent, for example, you don't think the grass is cut often enough, or you don't like the security company that they're using, that is no defense against the non-payment of levies in court. You have an obligation to pay levies, and if you think you have a claim against the body corporate, you must institute action against the body corporate, and only if you have a judgment, then you will be allowed to set that off against any amount owing by yourself against the body corporate. So body corporates rarely lose matters in the courts, because there is a legal obligation on the owner to pay levies. Only if levies were charged and the right processes were not followed when levies were determined. For example, levies were divided equally amongst 30 units in the scheme, but they're not all the same size. Then you have a defense because the participation quota wasn't used. So then you will be able to defend it because it wasn't your allotment was not correct. So therefore you would then have a defense, but not for the total amount, only in as much you have paid more or
Proportionate.
proportionate, correct,
Okay.
to
So,
that.
so if I'm looking to buy a property and I look in a complex where one of my friends owns and they told me they pay 2,000 rand for the levy, I need to check, is their unit a two-bedroom unit? Am I buying a three-bedroom or one-bedroom? And I need to expect a different amount for myself. Where would I find out what my amount should be?
Well, firstly, when you purchase the property, the estate agent that deals with that property should get the financials from the body corporate. In general, the managing agents wouldn't want to disclose that to everybody.
I was
They
about
they
to say.
they come up with poppy.
Yes.
But one would then actually just make use of your seller to obtain all that information, because owners are entitled to all information of the scheme. So they would then ask for the financials. They will have their levy statement, so they will be able then to show the new prospective purchaser, this is what you will pay in respect of levies. And what is also important is the rules. The agent should get the rules of the scheme and the sectional plan to understand what the person is owing, because we have not even touched that, but there's also common property that where people can have exclusive use of that property. In general, it would be the gardens or the garages or the carports and so forth. That's also common property, but you have the exclusive use of that. And there's also a levy in respect of that exclusive use area that should be charged. And then a CSOS levy, the Community Scheme Ombud Services. So they also charge a levy on a monthly basis to all owners. That is also forms part of the levies payable. So the estate agent should actually collate all that information, and when you purchase the property, that should be made available. And as a prospective purchaser, I would think that you would have to go through the financials. If you buy a company, you would never buy a company without looking at the financials of that business and understand what you're buying. But people buy property without looking at the financials of the scheme, without understanding. But there's a scheme here, they owe 2 million rand to the city of Joburg, And when you purchase in that, you're purchasing into that debt. You become liable for that as well as an owner. So important to look at the financials, look at the arrears, what is being paid, how many people are not paying, is legal action taken against them? Because if you've got a reluctant board of trustees that don't want to take legal action against owners, then you're going to sit with a problem that there's less and less levies available to pay the same expenses. So it means that the scheme will actually have to increase levies because less people are paying so that they can have sufficient money to pay the expenses. And the ultimate problem is that the scheme is not maintained. So if people are not paying levies, then the scheme won't be maintained as well. So your investment in that scheme is then at risk. What you bought at 600,000 or R1,000,000 will be worth less in 2 or 3 years if the scheme is not maintained, or the electricity and water gets disconnected to that scheme frequently. Then nobody would want to buy in that scheme.
Gosh, there's so much to unpack here. So basically, if I'm buying in a scheme, I'm like a shareholder buying a few shares in a company. So I need to understand that the debt is part
A very nice analogy,
of the
yes.
thing. So absolutely, I have to look at the financials and all the other aspects that you mentioned, and what about the managing agent if they're not managing properly? So in other words, everyone's paying their levy, but we're spending the whether it's the managing agent, or you can explain also what's the difference between the trustees and the managing agent, and how this is governed, so that we make sure they're not spending 100,000 on painting when it should cost 50,000. So how does this work?
Sure. Yeah, we're now going deep into this. So the trustees, in terms of the legislation, and if we talk sectional title and not HOA, because there we have directors, but the trustees are like the directors of a company. So they are the people that are the day-to-day people that are in charge.
Are they
And
owners?
they don't necessarily have to be owners. So the Act does not require people to be owners to become trustees. It must just be somebody that is nominated by owners and that are voted for by owners. So I know quite a few people that sit as trustees on schemes because they've got legal knowledge, and they are then required to go and sit there because the scheme wants somebody with legal knowledge to actually assist, or people that are accountants that sits on schemes and then assist the scheme with financial budgeting and financial issues. So you do get people that sits on these schemes. They would generally be paid trustees, so
I was about to ask, yes.
it won't be for free. Owners can't be paid trustees unless the other owners have agreed, but an outside person can be a paid trustee. So I can go and sit on a board and I can give them advice, legal advice in respect of how to run the scheme compliantly, and I can charge a fee, and if they agree to pay that fee, then I can sit there. But where I'm in my own scheme, I'm not allowed to do that. If I sit there, then I must do it for free unless the owners say, okay, we'll pay him because that's his profession, so we'll pay him for that. But in general, that doesn't happen. So that's the first aspect. The managing agent is a service provider. So they are appointed by the trustees, and the trustees then instructs them what to do. So in general, they would send out levy statements, they would look at the maintenance, they would budget. So all the day-to-day activities that is required at a scheme is then outsourced by the trustees. They then get reporting back from the managing agent, and they would then give them instructions what to do as well.
Can you have trustees without managing agents, and can you have managing agents without trustees?
You have schemes that are self-managed. So there are lots of schemes in South Africa that are self-managed, where they have their own staff. The scheme then is then run by its own staff. So definitely you can have. You can also now, in terms of the Act, there's a new concept that came into existence, which is called an executive managing agent. So an executive managing agent step in the shoes of the trustees, and is also a managing agent. So they can then manage as if they are trustees. So they have executive powers to make the decisions, but then also execute. We also see that some executive managing agents act only as the trustees and not as the managing agent, and they would then appoint a further managing agent that
Wow.
then fulfills the managing agent tasks. So there are schemes that are running like that as well. So in essence, they have two sets of managing agents: one an executive managing agent and one a normal managing agent.
Doesn't this make
Makes the levies expensive.
yeah.
It normally does. It normally
Okay.
because you're paying for two sets of
Yes.
people that can generally do the same tasks as well.
As a buyer, do I have a means to know that I've got this double layer situation when I'm buying, or not really?
Question to be asked
Question.
to the seller.
Yeah.
What is the situation with the managing agent? And then there's a third option, and I said that when we started. I run a company called Conveyancer Administrative Solutions. So we appointed by the court to administer schemes as if managing agents, but also as the trustees, but also as owners. So we step in the shoes of everybody by way of court order, and that happens when the schemes are dysfunctional and they need specialist advice and specialist people to sort out the problems.
How often are schemes dysfunctional?
Sure, lots. Currently in South Africa, there are many schemes, and we see it more and more, and we also even sees it where they are new schemes. So we see brand new schemes just developed that requires an administrator to come and sort out the problems from the developer to the owners and so forth. So there's a lot.
And when you get appointed, is it indefinite or?
No, it's not. In general, the court will ask us how long it will take, in our experience, to remedy the problems. In general, if the problems are levy related, it takes us about 3 years to collect levies from issuing of summons to sale in execution, something that you asked earlier on. I forgot
Yeah.
to actually mention that. So it does take a long time, and we would require about a 3-year period to actually sort that problem out and to make sure that the levies are collected, that owners either pay or those units are sold in execution. So in general, 3-year periods are the norm to appoint an administrator as an initial period. And then if the administrator has not completed the tasks that needs to be done, then you can approach the court and ask for an extended period. In the past, we have seen administrators almost appointed indefinitely, and that created problems because those administrators sometimes sit there and they don't really work to resolve the issues of the scheme, and it just becomes the management of the scheme, and there's no attempt to actually resolve all the issues, and that's a problem. So currently there is no real legislative framework in respect of that, but it is one of the things that we are working on in respect of training and so forth, to actually at some stage get the PPRA to require a certain level of training before you can administer schemes and sort that out.
Yeah, I was going to ask, if I'm an owner and I feel that the managing agents that are running our scheme are not doing a great job, do I actually have any recourse? Or even if the trustees, I feel that are maybe making decisions that are self-serving, and here I sit as a, just a one of the owners, what do I do?
So schemes are run as a collective. So that means that people must work together to sort out the problems of the scheme. So the owners need to work together. And if owners are not happy with the managing agents or the trustees, then obviously yearly they've got the choice to elect new trustees. So at every AGM, new trustees can be elected. Owners can also give directions to trustees. So if they're not happy with a managing agent, they can direct the trustees to start looking for a different managing agent. So they can do that at an AGM yearly. Alternatively, if 25% of owners are unhappy with a certain aspect, they can ask the trustees to call a special general meeting, and then the trustees are obligated to call that meeting within 14 days. So it doesn't mean the meeting must take place in 14 days. It means that the trustees must call the meeting in 14 days. And then owners can vote to remove trustees, or they can vote to appoint another managing agent, or whatever the issue is that they are not happy with. So ultimately, the control of schemes lies in the hands of owners. And if the majority feels that they're happy, and you are one single person that are not happy because your dog is barking and you're getting a letter that says your dog is barking and you don't like that, then the owners, the majority, is not going to follow what you're saying. And at the end of the day, I would think it's better than to rather sell and move on to a complex where they allow pets than be in a complex where you get a problem with that. It's managed as a collective by the owners. The owners have the ultimate control of their scheme, and you need, as owners, to take responsibility in that regard. But unfortunately, we also see that owners don't know their rights and obligations. So it's a big
Yeah.
problem in South Africa. It is something that we have been speaking about a lot in the industry, that the bank should require owners to actually go through some sort of training before bonds are granted in schemes. Trustees require some sort of training to actually serve as trustees, but these things are not reality as yet.
Yeah.
So it's something that the industry is talking about. The first step in the professionalization of the industry, I think, was taken by the PPRA when managing agents was separated from estate agents, so they're not the same people anymore. Managing agent requires a different Fidelity Fund certificate than a estate agent. And 2 years ago, we were working, and I was intimately involved in the creation of the framework that will be required of all managing agents to go through the training that they would require, or what would be required from them to be done before they can get a Fidelity Fund certificate. So we are moving to a situation where a training is going to be required, like with estate agents, the NQF4 and the NQF5 training that is required. We are going to see that shortly, that is also required in respect of managing agents, but then it relates to managing of schemes.
And that's great to hear, because we do often come across situations where a buyer would actually know that they should do their research and their due diligence, and they ask for financials, and the answer from the managing agent will be they're not ready. And that will bring me to the question, how far back, or rather, should I say, should the financials for 2025, which is year ending either February, or let's say, or August 2025, should they be ready by May 2026, or can they
So
say no?
the act requires it to be done within 4 months of the financial year end. So the advice that I generally give is for owners or managing or agents, if they want to sell and the financials are not available, to actually send a letter to the managing agent, include the trustees, and say you have a fiduciary duty. Part of that is to get the financials done within the 4 month period. I want to sell my property. My purchaser wants to see the financials. I'm losing out on a potential buyer. If I lose the sale and I have to sell the property later on at a reduced value, I'll hold the scheme liable for that, or the trustees in their personal capacity, because they have a fiduciary duty towards the scheme. That in general gets people to start moving.
I would get a bit of a fright, yes.
So generally, okay, well, this can have an influence on my unit, on my property. So maybe I must just get the people to start doing their work and find out what is happening with that. So that is normally the suggestion that we give, is just just put some pressure. Just put that pressure on and get that done. And then at the end of the day, if it's not done and it's a year, 2 years later, then obviously get that 25% of owners together. get rid of the trustees, get rid of the managing agent, get somebody in that understands compliance, that wants to make sure that the scheme is compliant and is run properly.
Yeah, that's great advice, and I think owners probably should just be a little bit more assertive when it comes to requesting that kind of information, because often people are unsure. Are they entitled to the information, and then they just kind of leave it, because the same we've seen also with plans. People just feel, well, there is no plans. I'm in a sectional scheme, but I don't have plans, and the buyer must just accept it, and that they're buying a property without existing plans. So how does that work?
So in terms of prescribed management rule 26 and 27, it stipulates that owners are entitled to all information regarding the scheme. And there's also case law of the Johannesburg High Court, a matter of Montrose Muse versus Muller, where the court actually said that owners are entitled to all of this information and must be provided, and a cost order was granted against the scheme for not giving the information. This was not a scheme that didn't want to give the information. Their rules had a particular manner in which the information had to be obtained, and the owner didn't follow that manner. And the court actually then found, and it was in accordance with the PIA manual, and the court said no, prescribed management rules 26 and 27 says that they're entitled. You can't put other conditions on to get it. Allow the owner to have all this information, and the court then granted the order against the scheme to give the information. So owners are entitled to that information. I think what else were we discussing? I'm just getting
No, I
sidetracked
mean
here.
there's so many questions, but basically, are they entitled to that, and also plans? Because that is a
Plans,
big question
yeah.
these
So
days.
plans are also for all sectional title schemes. There are sectional plans. So the sectional plans will show what you are actually purchasing. So you will know, this is my section. You will know my garden is an exclusive use area, or it is just common property. So that means everybody can actually braai in the garden. Or my garage is mine, it is part of the section, or no, the garage is merely an exclusive use area. It can be a registered exclusive use area in the deeds office. It can be a rule created exclusive use area. So those things you will see from your sectional plans, they are available. All schemes, when they are set up, that information has to go to the Surveyor General, and that information can be obtained fairly easily. So where schemes or where owners are saying, well, we can't get it, reach out to your conveyancer. Your conveyancer will, in all probability, be able to get that for you fairly quickly, so that you can actually know what you are selling, because it's important to understand the balcony. Is it part of my section? Is it not part of my
Yeah.
section? What is the situation? Who's responsible for the maintenance and upkeep of that? So you need to understand those things when you purchase.
And that's now so important to understand in terms of maintenance and upkeep, because we constantly having issues where a geyser will burst, and our owners assume in sectional title that that's covered by the levy and the insurance. And you told me something different last time, so I would love to share with people what is it that I can expect that is covered, and what kind of the maintenance, that half brick, halfway through the brick on the inside, is it me? On the outside, it's not me. Just walk us through that.
Sure. So warm water reticulation, in terms of the act, is actually the owner's responsibility.
I'm horrified to hear that.
But that's how it is. Um, However, in general, schemes would include that in their insurance policy, but they are not obligated to do so. They're only obligated to do so if the owners have made that decision at an annual general meeting, where they then instructed the scheme to then insure the geysers and the warm water reticulation. And then in general, the levy will then include your geyser. The scheme will have the policy. The scheme will then claim from the insurer, and the owner will be liable for the excess in respect of that geyser that is replaced. But if it is not included, so generally the bursting of geysers and the resultant damage that follows as a result of that places a huge burden on the insurer to pay out thousands of rands. I have recently seen in a scheme that 2 claims were more than what the total premium for the year of the scheme was in respect of the insurance. So all that means is that the next year the insurer will either not renew the policy, or they will just increase the levies or
Too much.
the insurance premium to recover that they've lost. So it's important for trustees to have a handle on those types of claims and make sure that those claims are not blown up, and because at the end it has an effect on all owners, because the premium will go up, meaning the levy will then go up. So yes, then regarding common property, the responsibility to maintain is on the scheme. If pipes serve only your scheme, then there is also the possibility that you will be liable for that. So it's the rules are not as easy. So it's always better to actually have a proper discussion with the managing agent, and make sure that they actually show you in terms of the rules what is the situation in respect of your scheme, in respect of any certain claim that you have. Um, but in general, you are liable for what is on the inside of your unit, and what is on the outside, that is the scheme's responsibility. So I always say you take and you shake. It's not what I said, it's Prof. Paddock, and I think an insurance friend of mine that's in the insurance industry, Mike Addison, he always says what you shake and what falls out, that is the owner's responsibility, and what is stuck, that is the body corporate's responsibility in general, but then with the exclusions of the warm water reticulation and so forth.
So if I'm about to purchase a property, and I should check then what is covered by the levy insurance, because let's say it's an apartment and a pipe bursts inside, and it's all the kitchen cupboards are wet and now they have to be replaced. I need to know that the complex insurance covers it, because it's most likely it doesn't, and I should have insured the interior.
Correct. So if the resultant damage follows as a burst of a pipe, that and you're responsible for that specific pipe, then the claim will not cover that, and that will then have to be claimed under your household insurance. And your household insurance might say, well, it is not movable. We've only insured the movables and not the immovable, and therefore it's not covered. So it's important to understand what is covered by that insurance policy.
So basically, check the insurance and make sure your personal insurance covers all that, because it can be a big surprise if you have to replace a kitchen.
Definitely.
Okay.
Kitchens are expensive.
Yes.
So check the financials, check the levy statement, check the insurance policy, check the plans. So these things need
Right.
to be checked. And a agent selling in sectional title should know these things, and should actually make sure that all that information is available when somebody wants to purchase.
Yes.
Rules, it's important to know what the rules are, because the rules are not all the same. Although the Act does have prescribed management rules and conduct rules, those rules can be amended by the developer when the scheme is set up, or by the owners during the course of the running of the scheme. Owners can, at a meeting then with the necessary authority, change the rules, and then it goes to CISOS that approves it, and then those rules are different from the rules of the Act. So it's important that you actually have sight of those rules as well.
So speaking of rules, often we come up with the whole thing of cats and dogs. So where are we on that? Because we had a situation where dogs were allowed up to a certain size, but then this dog within the size limitation appeared, and then it was perceived to be a dangerous dog, then it wasn't allowed. Then there were big fights and so on. And then people will say, but if I can have dogs, I should be able to have cats, and so on. So is there any fixed rule, or is it scheme dependent? And what are the rights of the owner?
So I'm not the big dog and cat fight expert, but in general, if pets are allowed, one can't discriminate between different types of pets. So if a scheme is a pet-friendly scheme, one can't say you can only have budgies, but you can't have parakeets, or you can't have A, but you can have B. So in general, if a scheme is pet-friendly, it should be pet-friendly in general. You can have schemes that completely exclude that. That is then completely excluded. But although it's completely excluded, if somebody is now blind, they need a guide dog, then obviously in terms of that requirement and the principles of fairness and what is required as a blind person, you would be able to actually have a dog in the scheme, but that wouldn't open the scheme up for other people to have pets. So in general, as I said, if dogs are allowed, one must also, and there is case law on that subject as well, is one can't discriminate against dogs. So you can't say A, B, or C, but we allow D. Can't do that. At the end of the day, it is what is reasonable. And the question is also, is it reasonable to have a big dog in a flat where there's no place for the dog to actually walk and so forth? But we do see in other jurisdictions, so if you look at the USA, Australia, and so forth, that these schemes don't have any gardens and so forth, and people take their dogs out to a dog park. And the courts have, in those jurisdictions, found that therefore a big dog can stay in a flat. But owners have a responsibility to then take their dogs out and take them for a walk. So I don't think we have seen the last of cats and dogs and all those fights. It's matters that come up continuously. And it's matters that generally goes to CSOS, the Community Scheme Ombud Services, that then make rulings in that regard. So they don't get to courts so often. So we generally then look at court cases from other jurisdictions, from Australia, from the USA, and so forth, to say, well, we think that this is what's going to happen in South Africa.
Interesting. Well, I definitely have seen a case where a dog wasn't allowed. So the tenant wasn't allowed to bring their dog, and it was a pit bull, but exceptionally well behaved and well trained pit bull with a certificate for being a service dog. So it was an emotional support dog. And yet the scheme did not allow that particular dog because they said that it frightens people on the premises. And I know for a fact it did go to some form of legal debate, but I can't say how far that went, and that tenant chose not to remain on the property. I
So
would
I
have
would
liked to see
think,
that fight play
yeah,
out to the end,
I
but
would
it
have
didn't.
thought they would have a very strong case to actually be able to keep their dog. That sounds
Especially with the service dog
correct.
certification.
So it
Yeah.
sounds as if it would have been a very strong case for them to push, but obviously it costs money,
Yeah.
and you would refer it to CSOS. If you're not happy with CSOS, then you can appeal.
How long does CISOS take normally? Do
Wow,
you want to tell me?
yeah, it's difficult. It's difficult to tell you. Um, Longer than it should. I would venture to say.
So
Don't
your
want to go.
dog might
Don't.
die of old age by the
Yeah,
time you finish fighting.
yeah. Unfortunately, things are not going as smoothly as one would want it to go. There is constantly an intent to improve that and to try and get it better. Um, it's not necessarily better. From our point of view, our business point of view, Stratafin's point of view, we rather go through the courts.
Wow.
It's
Okay.
for us the time periods is just better going through the courts. So we don't really generally make use of the CSOS process and procedures. And we've also seen some very strange judgments by them or orders by them, which we then had to take to the High Court and set aside, and that takes another year to do that, and then only can you start with the real issue again. So from our board, we have made a decision that we rather go through the courts immediately and follow that process.
Interesting. So, I mean, speaking of you're thinking of some examples, but I mean, I'm thinking of a case currently that we're dealing with where the managing agent refused to issue clearance certificate to a seller because there is some ongoing dispute with a leak between our seller and the person under them. The managing agent is of the opinion they have to pay for some damage. The seller believes they don't need to pay because they didn't cause the leak. It was pipes, and we're back to that whole pipe story. But they believe and they say they have an opinion that the pipes are the responsibility of the sectional title. So can the managing agent withhold that clearance for the sale to go ahead?
Not at all. There's case law that specifically prohibits that. So the only amounts that can be placed onto the levy account are the levies that were legally raised in accordance with the decision of owners and trustees. Then legal fees once it's taxed or agreed, interest, and then obviously your consumption, so your water, electricity, those types of things. So where there's a disputed amount and a court has not ruled on it, one cannot put that onto the levy clearance figures, and you cannot for any other reason. So even if there was building work that has taken place, and the scheme requires the owner to now remove, they've enclosed the balcony or something like that, and it was done without permission, you can't withhold the levy clearance certificate unless you have obtained an order from court that then authorizes that the amount of the removal for the balconies enclosure must be recovered from the owner. So only if you've got that order, then you can add that to the clearance certificate. But prior to that, you can't. I'm not so certain it's a good outcome. It does place schemes at a disadvantage where people do things that they shouldn't do. But that is the law as it stands currently. So you can't withhold the clearance certificate.
Okay, well, that's great to hear. But like you said, the whole enclosing of balcony story, and the
Sorry, did
various
I open
other
another can of
the
worms?
various other cases that we see, people add carports, to their specific property and so on. So how does that work? Can I just add stuff?
Not at all.
Yeah.
So remember, it's common property. You own from the middle of the brick to the inside. Whatever is on
Okay.
the outside is common property. So if you are erecting a carport in the garden and you think it's your garden, but it's not, it's common property, it belongs to everybody, then you are actually now building on common property. Also not as simple as that. Because in general, when a township is established or zoning rights are given in respect of property, those zoning rights determine the limit to which extent may be built or covered on the property. And if people are just putting up carports willy-nilly, enclosing balconies, then it exceeds that coverage that is allowed. So even the trustees, if they allow it, but they are acting outside the act, then they are acting ultra vires, so they're acting outside the law. They can't authorize something that is not allowed in law to do. So definitely it is important that professionals be brought in to advise in that regard. Where you want to do those types of things, there are processes where schemes have not reached their coverage, where people can get extensions, where common property can be used to be included into sections, and the sections can be made bigger. But then the sectional plans needs to be changed, the PQ needs to be changed, so the owner will now pay a slightly higher levy because he's now got an additional bedroom or whatever the situation might be. So definitely better to get the professionals involved to explain how things should be done and do it properly.
Okay, and then a question that we often get asked because people try to understand what do I own, and we've explained that now, but what if the whole building burns down, and now we're having an insurance claim, let's say, so what do I get as an owner of my one bedroom apartment?
Okay, so is the property bonded or unbonded? So different outcome. If the property is bonded, then the proceeds of that insurance policy in respect of your section will be paid to your bondholder because his interest is noted against
That would be the bank.
So the bank will then be paid,
Okay.
correct. So the bank will be paid in respect of their bond, and say the property was insured for 700,000, and the bond currently is 500, then there's 200,000 that comes out that will go to the owner, but the bank will be paid off. Then obviously now the land is burned, there's nothing left. And then if they decide to destruct the scheme, then that land will be sold and all owners will be then entitled to their little portion in terms of the participation quota in respect of the land. Obviously, the scheme can also decide to rebuild, so they can take the money and
Special
rebuild.
levy.
They can rebuild the scheme. So we see in Natal when the big storms are there and a portion of the building is washed away, and the insurance pays out, then the scheme takes that money and they fix the whole thing, and the section is replaced with a new section that's exactly the same as the old, and the bond is then still over that section because it still remains the section, and it carries on. So it depends what the decisions that are taken. If the property is unbonded, and there is an insurance event and the building burns down and the scheme is destructed, then obviously the owner will be paid out in respect of his section what it was worth, that it was insured for, and also if the land is then sold, then he will also get his portion in that regard. So the owner will then get that. If your property, if the scheme, and the scheme has an obligation to determine the insurance value on a 3-yearly basis, if they insure the scheme at 10,000 Rand a square meter, but your unit has got very particularly nice finishes, and you have finishes that makes it now worth 15,000 Rand a square meter, then your bank can require that your insurance premium be up for that additional 5,000 Rand a square meter, and you as the owner will then be liable. So that will be one of those amounts that will go onto your levy account that you're liable for, and the whole of the scheme won't pay for that, for those nice taps that you've got in there now and the nice bath that you got in your scheme. So that will also go onto your levy account, and you will be liable for that little difference between what the normal insurance is and the insurance that your bank requires.
As an agent, I would definitely say don't overcapitalize on sectional title because if you are pricing yourself completely outside of your neighbor, it's ultimately the buyers comparing one bedroom apartment with another one bedroom apartment. They might not like my shiny gold taps. They might want their taps to be bronze or whatever the case may be. They'll never pay for that extra amount. So rather keep it kind of the same as everyone else in the scheme.
Must agree with you.
Yeah.
I must agree.
So I mean, you get involved with administering delinquent schemes. You get involved in purchasing the debt and helping sell off properties and all that. So, would you say that this is something that will grow in future, and there will be more people like you and more companies like yours? Is there a lot of demand for what you do?
There definitely is. The market has grown tremendously in the last 10, 15 years. When I initially started in sectional title by managing schemes, the figure was thrown around that there's about 60,000 schemes in South Africa, and the figure that is now being thrown around is about 120,000 schemes, so doubled in the last 10 years. So definitely a growing segment of the market, sectional title. I mean, we see big schemes down the road. Munyaka, I don't know how many thousand units sits there.
Yeah.
In Pretoria, the same type of scheme there, thousands of units. So definitely schemes living is something that is desirable because of security, I would think. And it's definitely growing. So yes, there's definitely an opportunity for professionals in the industry, but the industry require people that are actually understanding the law, understanding the obligations, and run schemes compliantly.
So when you say understanding the law and obligations, we often deal with people who want to enter the investor market, and they will say, I'll buy a piece of land, I'll sectional title it, and then I will, let's say, build a block of 20 apartments. But then I'm not going to set up anything else because I'll keep them for now and just rent them out as an investor. Do they, if something is subdivided and into a sectional scheme, whether that is 20 apartments owned by one person or whether it's the interesting case of the duets in Pretoria, where one property, they drew a line in the middle, then it became two properties, but it is under sectional title. Are there still obligations, even though in the Pretoria case it's just two owners, and in other cases, it's one investor who then built all the apartments and is not selling them? Do they still have the same rules and laws?
So a sectional title scheme comes into existence on transfer of the first unit to somebody else than the developer. So, so until such a time as the developer on sells that unit, it is not a sectional title scheme as yet. And there is, so he's the owner of that single property with 20 units in it,
So he can
and
run his
he
own
can run it, and
kingdom.
correct. So it's his kingdom. He can do what he wants. The moment that he starts selling units, then obviously he falls under the Sectional Titles Act and the Sectional Title Schemes Management Act, and he must be compliant with that.
But quick question, because we then have the flip side where an investor says, find me a building where all 10 owners want to sell, and I'm going to buy them all, and then I'll be the sole owner. Is it already a sectional title?
So it's already a sectional title, and you're now the owner of all the units. Then you can retain it as a sectional title. And you can also remove it out of the sectional title register because you're the owner of all the units. So you can
Okay.
take it out, but you can also leave it in if you want to later on sell it. You will have an obligation to pay CISOS levies, but because you're the owner and you make the decisions now, so you the trustees, you the everything in respect of the scheme, you can determine the levy to be zero,
Okay.
and you don't have to charge a levy, but you are a sectional title scheme, you are registered as such. There have been a scheme that came into existence, and you will then have to pay CISOS still their levy, because they are entitled to recover levies on all schemes. But I would advise under those circumstances to remove it out of the sectional title register and just keep it as a single property.
Okay. And the duets?
The duets is a very interesting case. People don't even understand that they are living in a sectional title scheme. They think it's like the old semis of Hillbrow and of can't now even remember, close to Rand Afrikaans University at Brixton, the Brixton semis. They were separate urban with a joint wall, and that joint wall was a shared wall, and there was a servitude in favor of that. And that's how they did it in the old days. Now they do a sectional scheme, and you have two units on, and they can be connected, and sometimes they're not even connected. But the land still remains common property. So your swimming pool that you think is your swimming pool is actually on common property. Your neighbor can come and swim and braai as well because it's on his property as well, because he has an undivided share in your property as well. So very interesting one. I would suggest that to deal with the duets, one need to then understand that it is a sectional title scheme, and you should change your rules to make it more as if it's freestanding. So you place the obligation to maintain the outside on the owners specifically, but in terms of the rules of that specific scheme. So I wouldn't use the normal rules, and where it was just done under the normal rules in the Act, I would actually then just consult somebody to say, assist us with drafting proper rules for this. Don't require financials, don't require maintenance obligations. Each one will be responsible for this. Each one will have their own exclusive use area and will be responsible, and so forth, and place the responsibility of the maintenance and upkeep and insurance on them separately in terms of the rules.
Is it too expensive or too onerous to just make them full title?
Well, sometimes you won't be able to make them full title because the size of the land is smaller than the township in which they are allows for separate stands. So you might have a stand that is 1,900 square meters, but the township rules in respect of that township that came into existence says that only stands over 1,000 square meters can be subdivided. Now you've got a stand that's 980 square meters, so therefore technically you can't subdivide, but it's literally 20 square meters, so 10 square meters on each side, too little, but the council's not going to allow it. And then you set up a sectional title scheme, and both of them have the 980 divided by 2. So not necessarily possible to subdivide. If it's possible, then obviously you can do so. The other obligation, obviously, once you subdivide, then there's an obligation to contribute to bulk services. And that's why lots of developers, in some instances, even where it's possible, they won't subdivide, because then they must be liable to pay bulk services to the council, and that then makes it not viable, financially viable for them to actually do that subdivision, because it just becomes too expensive, and that's why they will follow rather the sectional title route. So it's dependent on the circumstances. One will have to go and look at what is the size, what are the rules in respect of that specific township, and so forth.
Okay. And then in the past, we all would share the electricity and water accounts. Nowadays, you've got your own electricity and water account, but then you get an extra electricity charge for the common grounds, and then certain owners then, get a bit of a surprise again. Yeah.
Yeah, so the old schemes were built with bulk meters, so bulk water, bulk electricity meters, and then maybe separate electricity meters, but those are just the scheme's internal meters, and then we charge postpaid. So they would go and read those meters and say, this is what you've used for your section, and they would charge you for that in accordance with the bill. And then there's common property usage for water and common property usage for electricity. So that's the electric fencing, the opening of the gate, the lights on the outside, the parking lights under the carports, and so forth. And that then gets divided between the owners in accordance with their PQ. So you would deduct all the internal usage from the account. What remains is then common property usage, and that you would then divide to the owners in accordance with their participation quota. So that's the old way of doing it. Obviously now separate water meters, separate electricity meters are generally installed, and then owners pay for their own water and own electricity, but then still there is common property electricity and common property water for the gardens and the electric fencing and so forth, and that then gets divided to owners in accordance with their participation quota. So yeah, so schemes that do have individual or do have bulk can, by way of special resolution, change that, and owners can then decide to install prepaid um, electricity and prepaid water meters, separate meters in by way of special resolution, or just a normal resolution if they just want to make it postpaid, but then it's metered. Um, then they can by normal resolution then install those meters and then determine what is used in respect of that unit. So water is particularly a problem in schemes, specifically because in a 3-bedroom, sometimes there's one person staying in a 3-bedroom unit, and there are 6 people sometimes staying in a 3-bedroom unit, and sometimes there's 10. Um, and then the one person in a 3-bedroom unit is paying exactly the
Yeah.
same for water than the 10 people in a 3-bedroom unit. And obviously the 10 people use far more water. So I think that the modern approach where all of those water meters and electricity meters are separate and metered, and your consumption is metered, is far more um, fair than doing it on a participation quota basis.
So, I mean, in general, basically what I'm hearing is we just need to be educated. We just need to know what we are buying. But ultimately, the shared responsibility also gives you shared benefits. So, whilst you might not be able to afford your own pool, now you share in the ability to swim the once or twice in the year that you're actually going to end up swimming, versus your full title property where you have to carry the cost of the pool daily, but you might not use it so much.
Absolutely.
Yeah. So sectional title is not a bad investment.
No, it's absolutely not a bad investment. However, it can become a bad investment if people don't understand the rules under which it operates and don't contribute and don't participate. It's important that owners also participate in the AGMs. I mean, we see at AGMs, we had an AGM 2 nights ago where there wasn't a quorum. So we asked for a meeting for a specific purpose. It's specifically regarding the maintaining of the scheme, and we couldn't even get 33% of
Wow.
owners there to make a decision how they want to maintain their scheme. So sometimes people need to understand that if you don't participate, at the end of the day, it has an effect on your property and on your investment. And in general, property is the single largest investment that any South African ever make in their
Yeah.
lives, and then they don't care. They just leave it in other people's hands and want to
That that's very, very important, and I think that applies to everything else. And sometimes we look after our cars more than we do after our properties, and we as agents then end up selling those properties for really low prices where it wasn't necessary. You know, if we just put a little bit more effort into getting to know what our rights and responsibilities are, and just fighting for our asset and making sure our asset is maintained, both from our side as well as from the managing agents and everyone else's side.
absolutely.
So go to your AGMs, people. Is
Yeah,
that what it is?
absolutely.
Any final thoughts you want to share with us?
Um, yeah, I just think one must also, when you purchase property, um, ask these questions of your agents, and make sure that you are dealing with agents like yourselves that actually want to understand these things, that are actually um, asking people like us that are experts in this field how these things work and what is required and so forth. So it's important to deal with people that actually is hungry for knowledge and want to understand these things and will then give a better service. So thanks for the opportunity, and it's the
No,
second
thank you very
opportunity that
much.
I have with you guys now, to actually assist with training, and it's fantastic that we can actually do that, and that it's important for guys like you that are in the selling part of sectional title to understand what happens on the other side of it.
No, I appreciate your time, and we look forward when you announce your next training course. We're definitely going to attend because I think it's important and there's always something new to learn. So, absolutely. Thanks a lot.
Fantastic. Thank
Okay.
you.